Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I represent green card holders in federal litigation to enforce the Affidavit of Support, and I serve as a consulting expert in family law litigation when the Affidavit of Support is enforced in a divorce proceeding. Today, we're going to talk about how a judgment that's used to enforce the Affidavit of Support can be collected against a sponsor. Probably the most important thing to start off with is to note that most of these claims result in settlement. So either before litigation is started or after a relatively limited amount of contested litigation, typically the sponsor will come to their senses and realize that it's going to cost much more to litigate this matter than to simply resolve it. So what we see time and again is that you have these claims resolved voluntarily through settlement, and involuntary collection measures aren't required. Oftentimes, these claims will simply result in a lump sum payment by a sponsor, or you might have a case where it results in a settlement plan that's structured where a sponsor pays a certain amount up front and then a set amount per month for a series of months until it's paid off and then the debt is resolved. But you have a small percentage of the cases, and it is pretty small, that get litigated all the way through to a judgment, and that judgment then has to be collected against the sponsor. And remember, even after you have a judgment, that doesn't mean that settlement negotiations are off the table. After judgment's rendered, the sponsor can still do the smart thing and work with the plaintiff's attorney to figure out a way to pay off the judgment rather than have it involuntarily collected against them. But let's take kind of the worst case scenario from everybody's perspective, and the sponsor is just digging in their heels and is just not going to pay that judgment. That does happen. The federal statute, Immigration and Nationality Act, specifically authorizes what we would consider all standard forms of collection methods. That includes foreclosure of property and wage garnishment. And we've used both of those against sponsors. Probably the most common thing to do is wage garnishment. So if you get your judgment, you can go to the sponsor's employer and garnish a percentage of the wages that come in. That's not great from anybody's perspective because this typically is a relatively limited amount, and this is going to result in a situation where you have months or even years of collections going on against the sponsor. The other alternative, the other primary alternative that we see is foreclosure. So if the sponsor owns real property, you can use the federal statute to foreclose that property. And we've had to do this also. So if the sponsor owns a house, you can, as soon as the judgment's rendered, start foreclosure proceedings against that. In the situations where we've had to do that to enforce the Affidavit of Support, what actually happens is once the foreclosure proceeding starts, that's when the sponsor realizes this is really serious and they're going to have to deal with it, and then they finally work out a settlement. But if they didn't, the house can be sold at foreclosure auction and the proceeds go to the plaintiff to repay that judgment. So bottom line is, it's most likely that a claim under the Affidavit of Support is going to be resolved voluntarily at some point. So either before litigation has started, during the litigation, or even after judgment has been rendered. Settlement is still on the table then. But if the sponsor absolutely will not cooperate, then you can use garnishment, wage garnishment, and foreclosure to make good on that judgment. Those are absolutely tools that are available to an Affidavit of Support plaintiff. Hope that's helpful. Feel free to jump into the comments if you have questions. Sorry for the tech snafu. If you have case-specific questions, you're welcome to reach out on the website. We work with clients around the United States, and we're happy to do a free case consultation for green card holders or lawyers who are interested in enforcing this in the context of a divorce case.